So to continue the report, we will be discussing 2048. So a guarantee is gratuitous unless there is a stipulation to the contrary. Generally, a guarantee is gratuitous. It is onerous only when there is stipulation to the contrary. We have this cause of contract of guarantee. Number one, the presence of cause which supports principal obligation. So what is this? The cause of a contract is the same cause which supports the obligation as to the principal debtor. It is unnecessary to prove any consideration as between the guarantor or surety and the creditor. So the consideration which supports the obligation as to the principal debtor is a sufficient consideration to support the obligation of a guarantor or surety. Number two is the absence of direct consideration received by guarantor. In this one, so the nature of the guarantee or the surety agreement is that it is regarded as valid despite the absence of any direct consideration received by the guarantor or surety, either from the principal debtor or from the creditor. So while a contract of guarantee or surety, like any other contract, must generally be supported by a sufficient consideration, and such consideration need not pass directly to the guarantor or surety. A consideration moving to the principal alone will suffice. So for a guarantor or surety is bound by the same consideration that makes the contract effective between the principal parties thereto. So another one is absence of direct or personal interest of guarantor over the obligation. So in this one, the guarantee or the surety becomes liable for the death or duty of another, although he possesses no direct or personal interests over the obligation, nor does he receive or any other benefit therefrom. So it is never necessary that he should receive any part or benefit, if such there be, accruing to the principal. Where a surety bond has accepted by the obligee, it becomes valid and enforceable whether or not the premium has been paid by the obligor to the surety. We have this case. So, in consideration to the dismissal of the suit by the creditor against the debtor, the latter agreed to pay certain amount with another as guarantor. We have the facts of the case. Upon the death of X, who left considerable property, a litigation ensued between C, X widow, and other heirs of X. A compromise was effected by which D, a son of X, took over the property pertaining to the estate of X, at the same time agreeing to pay 100,000 pesos to C, payable first in 40,000 pesos cash upon the execution of the document of compromise in the balance, and 3 equal installments. So in this, G affixes name as guarantor. Upon D's failure to pay the balance, C instituted action against D and G, the latter contending that he received nothing or affixing his signature as guarantor to the contract, and in that effect, the contract was lacking in consideration to him. So the issue of this case, is there a consideration for the guarantee? So the court held that, first, a guarantor or surety is bound by the same consideration that makes the contract effective between the principal parties thereto, So the compromise and the dismissal of a lawsuit is recognized in law as a valuable consideration, and the dismissal of the action, which C instituted against D, was an adequate consideration to support the promise on the part of D to pay the sum stipulated in the contract subject of the action. And another is, according to the court, that it is neither necessary that the guarantor or surety should receive any part of the benefit, if such there be accruing to his principal. The true consideration of this contract was the detriment suffered by C in the former action in dismissing that proceeding, and it is immaterial that no benefit may have accrued either to the principal, which is D, or his guarantor, G. So this is the case of Severino and Vergara versus Severino, 56 Philippines, 185. Now let's go to Article 2049. A married woman may guarantee an obligation without the husband's consent, but shall not thereby bind the conjugal partnership except in cases provided by law. So a married woman who acts as a guarantor ordinarily binds only her separate property. However, she may also bind the community or the conjugal property or partnership property with her husband's consent, and even without the consent of her husband in cases provided by law, such as when the guarantee has redounded to the benefit of the family. So there is no express prohibition against a married woman acting as guarantor for her husband. We have also 2050. So if a guarantee is entered into without the knowledge or consent or against the will of the principal debtor, the provisions of Article 1236 and 1237 shall apply. So we know that guarantee is generally unilateral. So, and not it exists to the benefit of the creditor and not to the benefit of the principal debtor, who is not usually a party to the contract of guarantee. The creditor has the every right to take all the possible measures to secure the payment of his credit. It is also, it can be constituted without the knowledge and even against the will of the principal. We have that the right of the third person who pays. So the rights of the third person who pays or perform the obligation of the debtor and who guarantees the obligation of the debtor are similar. So this is the rules on payment apply. If a person who pays without the knowledge or against the will of the debtor can recover only insofar as the payment has been beneficial to the debtors. It is provided in Article 1236. And he cannot compel the creditor to subrogate him in his rights, such as those arising from a mortgage, guarantee, or penalty. It is also provided in Article 237. So if he become guarantor with the knowledge or the consent of the debtor, he is subrogated by virtue thereof. So all the rights which the creditor had against the debtor. Let's go to Article 2051. A guarantee may be conventional, legal, or judicial, gratuitous, or by onerous title. It may also be constituted not only in favor of the principal debtor, but also in favor of other guarantor with the latter's consent or without his knowledge or even over his objection. So the manner or the creation, a guarantee may be conventional, legal, or judicial, gratuitous, So the legal guarantee is imposed by law to secure the compliance of certain obligations. Judicial guarantee is constituted by decree of court. So it should be by decree of court and not by provisions of law or by the agreement of the parties. The legal guarantee cannot be constituted without an express provision of law. So the provision of law should be interpreted strictly. And we have also this, what we call double or sub guarantee. What is this? So the double or the sub guarantee, or one constituted to guarantee the obligation of a guarantor. It should not be compounded with guarantee wherein several guarantors concur. We have also Article 2052. A guarantee cannot exist without a valid obligation. Nevertheless, a guarantee may be constituted to guarantee the performance of a voidable or an enforceable contract. It may also guarantee a natural obligation. So guarantee is an accessory contract. We should take note of this. It is an indispensable condition for its existence that there must be a principal obligation. So if the principal obligation is void, so the guarantee also is void. Please take note also that 2052 speaks of a valid obligation. So a signatory to a guarantee agreement is liable on a promissory note for an unpaid loan obtained under an agreement, although he did not sign the promissory note. We have this, the case. So guarantors are being held liable under a bond filed to secure compliance with a contract which was subsequently cancelled. So the facts of the case. The municipality of Quezon granted to the fishing privileges within its jurisdictional waters. To secure the payment of the license fees for the said privilege, D filed a bond subscribed by J and H, who bound themselves to pay if D failed to comply with the terms of the contract. So this contract was, however, declared by the Executive Bureau to be illegal. Accepting this decision, the municipality thereafter awarded the privilege to another person, who not only failed to make the deposit required, but formally yielded the privilege granted to D or any other person selected to the municipal authorities. The municipality, when advised D that the contract was to become effective. In a case that subsequently arose, the municipality sought to recover from D, J, and H an amount representing part of the license fees which D failed to pay for the privilege granted him. So the issue of the case: are the contract and the bond valid and enforceable? So the court held that no, the contract was not only consummated but was cancelled. It ceased to be valid from the time it was cancelled, and this being so, neither D nor G and H were bound to comply with the terms of their respective contracts of fishing privilege and guarantee. So a guarantee cannot exist without a valid obligation. So this is the case of Municipality of Quezon versus Marasigan, 63 Philippines 510. And now another case. So Surety Company seeks recovery of renewal premiums on bonds which were already null and void upon the grant of tax exemption to the principal. The facts of the case. So the P withdraw from the Bureau of Customs shipments of imported goods which were subject to custom duties and other taxes. After imposing surety bonds to cover the taxes due thereon pursuant to Republic Act number 4086 because its applications for tax exemptions for said goods were not then approved by the Board of Industries. In consideration of the obligation assumed by S, the surety company, P agreed to pay the premiums and the cost of documentary stamps in advance due on the bonds for each period of 12 months beginning March 1965 until said bonds and its renewals, extensions, or substitutions can be cancelled in full by the person or entity guaranteed thereby or by a court of competent jurisdiction. Condition number 2 of the original surety bonds reads, so that in case the application is approved by the Board of Industries, then this bond shall be null and void and of no force and effect. P stopped paying premiums and cost of documentary stamps after it was granted tax exemption on December 19, 1966. S maintains that it has renewed the surety bonds in March 1966, more or less 8 months before the application for tax exemptions was granted. So what is the issue of this case? Is P liable for accrued premiums and cost of documentary stamps on renewals of the surety bonds after the grant of tax exemption to S? So the court held that no, suretyship cannot exist without a valid obligation. The purported renewals were without consideration at all. S incurred no risk from the time P's tax exemption application was approved. Any renewals were void from the beginning because the cost or object of said renewals did not exist at the time of the purported transaction. S would not possibly be liable for any violation under the original surety bonds, which were already void and of no force and effect, nor was there a need of formal release of the surety bonds by the Board of Industries or the Bureau of Customs. By express stipulation of the parties themselves, the surety bonds become null and void upon the grant of tax exemption. So this is the case of Plaridel Surety and Insurance Corporation versus Artex Development Company Incorporated, 120 SCRA 827. And now, it is said that a guarantee may be secure the performance of A. Number 1, we have the voidable contract, inasmuch as such contract is binding unless it is annulled by a proper action in court. So we have also the unenforceable contract because such contract is not void. And number 3, a natural obligation, so that the creditor may proceed against the guarantor, although he has no right of action against the principal debtor for the reason that the latter's obligation is not civilly enforceable. When the debtor himself offers a guarantee for his natural obligation, he impliedly recognizes his liability, thereby transforming the obligation from natural to a civil one. And now let's go to Article 2053. A guarantee may also be given as security for future debts, the amount of which is not yet known. There can be no claim against the guarantor until the debt is liquidated. A conditional obligation may also be secured. So the guarantee in this article includes a continuing guarantee or suretyship. It is not limited to a single transaction, but contemplates a future course of dealings covering a series of transactions, generally for an indefinite time or until revoked. So it covers all the transactions, including those arising in the future, which are within the description or the contemplation of the contract of guarantee until the expiration of or termination thereof. So future debts, even if the amount is not yet known, may be guaranteed, but there can be no claim against the guarantor until the amount of the debt is a certain or fixed and demandable. So the reason is that contract of guarantee is subsidiary. So to secure, we have here that to secure the payment of the loan at maturity. So the surety agreement, by the terms of which the surety binds himself to guarantee the punctual payment of loan at maturity and all other obligations or indebtedness which may become due or owing to the principal by the borrower, with any expenses which may be incurred by the principal in collecting such obligations or indebtedness, provided that the liability of the surety shall not exceed at any time as a specified sum, is a guarantee of future debts. And we have this number 2, to secure payment of any debt to be subsequently incurred. So what is the meaning of this? A continuing guarantee or surety is prospective in its operation and is generally intended to provide security regarding future transactions for an indefinite time or until a certain period. So we have that from the contract, which states that the guarantee is made from time to time, or obligations now in force or hereafter made, or it will be it will be construed to be a continuing one. So those are a continuing one from time to time, or obligations now in force or hereafter made. So in this one, using those words and expressions such as we have any debt, any indebtedness, any sum or guarantee of any transaction, or we have also money to be furnished to the principal debtor at any time or on such time that the principal debtor may require, have been construed. So what is this? Construed to be a continuing guarantee. So the continuing guarantee is recognized exemption to the rules. So what is this? That an action for the to foreclose a mortgage must be limited to the mention in the mortgage contract. So in all instances, a contract of guarantee or suretyship should be prospective in application. It must be construed as a continuing when the terms thereof, it is evident that the object is to give a standing credit to the principal debtor to be used from time to time, either indefinitely or until a certain period. Especially the right to recall the guarantee is expressly reserved. And we have also this number 3, to secure existing unliquidated debts. So this is future debts. So it must also refer to debts existing at the time of the constitution of the guarantee, but the amount thereof is unknown, and not to debts not yet incurred existing at that time. So a surety is not bound under any particular principal obligation until the obligation is formed. So we have also example. For example, D and C are partners in business. G may guarantee the payment of D of C's share from the profit of the business which has not yet been ascertained. So under this article 2053, G cannot be liable to C before such share is liquidated. And we have this guarantee of conditional obligation. So obligations to be incurred on the happening of a condition are covered by the second sentence of article 2053. So A conditional obligation may also secured for its valid and binding just like a pure one. So we have that a guarantee may secure of all kinds of obligations, be they pure or subject to a suspensive or resolutory condition. So if the principal obligation is subject to a suspensive condition, the guarantor is liable only after the fulfillment of the obligation. So we should take note of this. It is subject to a resolutory condition. Happening of the condition extinguishes both the principal obligation and the guarantee. A conditional obligation may also be secured for its valid and binding just like a pure one. And lastly, we will go to, for my part, Article 2054. So a guarantor may bind himself or less, but not more than the principal debtor. So both as regards the amount and the onerous nature of the conditions. Should he have bound himself for more, his obligations shall be reduced to the limits of that of the debtor. So the guarantor's liability cannot exceed the principal obligation. So number one, guarantee is a subsidiary and accessory contract. So as what I have said earlier, it is only an accessory contract. It exists because there is a principal contract. So it is because of this, because it is subsidiary and accessory contract, the guarantor cannot bind himself for more than the principal debtor. Even if he does, his liability shall be reduced to the limits of that of the debtor. But a guarantor may bind himself for less that of principal. So we should take note of this. We have examples. So D borrowed from C 10,000. If C guarantees to answer for 15,000, the guarantee is not rendered void, but he can be made to pay only 10,000 because his obligation cannot exceed the limits of the obligation. So if the debt is not secured by mortgage and G mortgages land in favor of C, the latter may not foreclose and mortgage otherwise. So G's liability would be more onerous than that of A, the principal debtor. So that is. So we have number two, the interest, judicial costs, and attorney's fees as part of the damages may be recovered. So creditors suing on a surety-ship bond may recover the surety as part of their damages, interest at the legal rate or judicial costs and attorney's fees when appropriate. So even without the stipulation, and even if the surety would become liable to pay more than the total amount stipulated in the bond. So in this case, so what is happening in this case? So the surety is made to pay, not by reason of the contract, but reason of his failure to pay when demanded and for having compelled the creditor to resort to the courts to obtain payment. So interest does not run from time the obligation become due, but on the filing of the complaint. So we should take note of that. So number three, penalty may be provided. So a surety may be held liable for the penalty provided for in a bond for violation of the condition. So after that, so we have these principal's liability may exceed guarantor's obligation. So now, the measure of the guarantor's or surety's obligation is not, however, the measure of the principal obligation. So the amount specified in the surety bond as the surety's obligation does not limit the extent of the damages that may be recovered from the principal. The latter's liability being governed by the obligation he assumed under his contract. So that's it for my report. Thank you so much.